Hey all, it's Steph here from Moving to Canada with my colleague who just so happens to be a registered Canadian immigration consultant. Thanks for meeting me today, Rebecca.
Hi, Steph. Happy to be here.
All right, so I have gathered you here at least. I was picking my way through a recent federal court decision on Mr. Liu's case. The cliff notes from the case are that Mr. Liu applied for permanent residency, and in that application, there was a marriage certificate for his wife. There was also children involved in the application. Immigration officials later discovered that the certificate was fake and asked him to explain what it was that was going on. At that point in time, he only sent divorce papers and never addressed why the certificate was fraudulent or why a fraudulent certificate was submitted as part of his application. As a result, his application was refused and he received a 5-year ban on applying. In the federal court decision, the court agreed that the immigration department's decision was fair. I'd love to unpack how misrepresentation works in Canadian immigration law. So yeah, Rebecca, do you want to just talk through misrep broadly?
So, misrepresentation under the Immigration and Refugee Protection Act, specifically paragraph 41A, means giving false or misleading information or withholding important facts that could change how IRCC assess an application. And it doesn't matter if the falsehood was intentional or not. What matters is whether it could have induced an error in administering the law. And the rule is really there to make sure the system is fair and reliable for everyone.
The decision kept stressing material representation. So what is it that makes misrepresentation material as opposed to immaterial?
Yeah, so material means that the false information is significant enough that had ICC known the truth or the misrepresentation not happened, the outcome might have been different. So in Mr. Liu's case, it came out of the fact that he submitted a fraudulent marriage certificate in his application, allegedly via an unethical or uncertified immigration consultant, but the fraudulent marriage certificate falsely added a dependent to his application, which could have been led to permanent residence status being awarded to that spouse that was listed on the fake marriage certificate. And so that's why it was material, because it could have changed how ICC processed the application and who was included in the application.
I did also see some cases recently where immigration consultants who, differently to this case, are actually registered and practicing in Canada, submitted documents or even entire applications on behalf of applicants without their permission. You did say that the mistake can be intentional or unintentional. So would that case still be misrepresentation?
Yeah, so misrepresentation can exist when it's even with authorized representatives. So when you do appoint a representative to work on your behalf, you must sign a form to add that representative to your file. And that form explicitly states, by filling out this form, you are appointing a representative to conduct business on your behalf throughout the application process. And then it goes on to state your representative will be able to complete or update your application and act on your behalf with IRCC. And so because of this, you're authorizing the agent to act on your behalf in whatever manner they seem fit. And so therefore you're liable for their actions of any representative you appoint.
Back to Mr. Liu's case, IRCC sent him a procedural fairness letter shortened to PFL. I'm wondering what the purpose of a PFL is.
So a procedural fairness letter is IRCC's way of highlighting concerns that they have within an application and giving the applicant a chance to respond before a final decision is made. The procedural fairness letter has some kind of requirements, and it must clearly outline the officer's doubts, like in Mr. Liu's case, the authenticity of the document, and ask for an explanation and give the opportunity for additional evidence to be submitted. So for misrepresentation allegations, procedural fairness letters need to detail the element of their concern. They need to make it clear, this is what we're concerned about and this is what it could result in. And then the applicant has the opportunity to address those concerns.
Okay, so in Mr. Liu's case, it seemed like it was a fairly big either mistake or poorly devised strategic plan to reply with the divorce judgment, but not explain why there was a marriage certificate that was fake. In that case, would admitting he'd relied on sort of a dodgy consultant have helped at all?
So unfortunately, it may not have. Applicants are ultimately responsible for everything in the file, even if a third party has presented facts. And in this case, the dodgy consultant may have done something without Mr. Liu's consent or approval. Courts have repeatedly held that direct or indirect misrepresentation count the same. So simply blaming someone else doesn't excuse the false information or documentation that has been submitted. In practice, though, I have seen many files avoid a misrepresentation finding during the procedural fairness process. So when you respond to the procedural fairness letter, if you can clearly demonstrate like the incompetent advice you've been given, this can help avoid a misrepresentation finding. But generally, if a misrepresentation finding is brought before the court, they've traditionally upheld the officer's findings. But I would say there is a shot of avoiding this at the procedural fairness stage.
Okay, so there is sort of some more human element to the process, but it's just never a guarantee.
Exactly. And it really depends on how you present and how you respond to that procedural fairness.
This is something people who are applying to immigrate to Canada through a consultant might not always think about perhaps as deeply as they should. We did want to point out that there are 2 hoops that you probably want to jump through when you're searching for an immigration consultant. The first is to make sure that they are registered to practice in Canada. We're going to drop a link on the screen here that you can use to make sure that your consultant is registered. It's the official Government of Canada website, and it's really the only resource on this that you should trust completely. But the second part of the process, which is the one that I didn't do a great job of, is that you want to do a little bit of diligence into, are they actually good at their job and are they ethical? This one, I think, is harder to check.
First and foremost, always check that the individual is authorized to represent you. And once you've got that confirmed, then you need to be confident that they're going to actually do a good job. People can like manipulate Google reviews and basically tell you anything they want to tell you in order for you to sign that retainer. I find that personal referrals are always a good place to start when looking for a representative. We do have our Facebook PR forum, and I do notice on several occasions people popping in saying, hey, has anyone ever used this representative? Do you have any feedback? Use common sense when filtering through the feedback. Everyone's situation is different, but there's some certain red flags that you should look out for. We do have a page covering red flags that you need to look out for when considering working with a consultant or a representative, and we'll put a link to that page as well, good resource.
Another thing that I noticed while I was reading it and that really stuck out to me was that intent isn't required. So it doesn't have to be like an intentional misleading. It can be like an accident that you leave something out. It seems really harsh. Can you be stuck with a misrepresentation finding for an innocent mistake?
So even neglect or innocent mistakes qualify as misrep if they are material enough. This zero tolerance approach underscores why it's really careful to document everything and have everything verified before submitting an application. I will say the difference between an intentional mistake and an innocent mistake is often an intentional mistake where you've actively decided that something is detrimental to you and made a decision to not disclose that.
Yeah, we don't have exactly the background on the fraudulent marriage certificate for Mr. Liu, so we're not sure if that one's intentional or an innocent mistake.
It would suggest that it was intentional. He may have been married and really thought he was married. With all these different legal requirements around marriage and dependent on jurisdiction, who knows?
So after the misrep finding, what options are left for people who are still hoping to immigrate to Canada?
The first thing is they can seek judicial review, but success is rare, absent new evidence or an error in the way the law was applied. After a misrepresentation finding has been passed, the applicant will continue to be inadmissible for 5 years, and that effectively bans them from future applications for 5 years. Their only option would be to apply for a temporary resident permit. And this type of permit allows an individual who has very valid reasons to enter Canada. So that it gives them the permit to enter Canada despite them being inadmissible. But it's not an easy thing to come by. When I say a valid reason, it has to be a very valid reason. You have to really have a compelling reason why you should be allowed.
The decision also referenced, it was GCMS notes. What are they? Can you quickly walk us through them and what applicants should do after refusal?
Yes, so GCMS notes are the Global Case Management System notes, and so that's the system used by IRCC to document what happens on a file. So it'll have all your file information, and it will have each officer's note. So when they pick up your file, they'll make a note that they did something. And requesting them can really clarify exactly why your application was refused, and it can help guide any steps that you take further if you're concerned about the processing of your file or a refusal that you received. So they can help you plan your next steps.
And one last thing, I think, is the duty of fairness. I read that it's low for PR applications, but higher when misrepresentation is an issue. How does that work?
So for most immigration files, IRCC only need to meet basic procedural fairness. So that is unbiased decision making. So you need to have access to an unbiased decision maker on your file, notice of issues that they have with enough information for the matter being considered, and the right to be heard. You need to have a chance to respond to the concerns outlined in the notice you receive. But when findings come with high impacts, there's an additional layer of procedural fairness, and that is reasons. So the applicant must be given an explanation on IRCC's finding which accounts for the relevant facts, context, and applicable law. Considering misrepresentation has the potential of having a big impact on the applicant, it carries a 5-year ban. The courts do expect more of a robust procedural fairness letter, which clearly states the specific concerns that the applicant has to respond to. And so in Mr. Liu's case, the officer met that duty by detailing the fraudulent certificate's history and asking them for an explanation. Procedural fairness was specific to that issue. And over the course of my career, I've seen procedural fairness letters which haven't met the definition of procedural fairness because they haven't clearly outlined what's required, what the problem is, and how the applicant needs to address it. But I do think as time has gone by, officers have got better at issuing procedural fairness letters. I think that there is also a human element to the way they process files. Innocent mistakes have generally, we've been able to overcome a misrep finding. They might still be refused because they're not eligible, but you can overcome within reason. But again, there's lots of cases where there's not an innocent mistake and something has purely been done to increase someone's chances. And to give you an example, I met with a lot of international students that were in Canada, and on their study permit, they would either not specify a certain level of education or they wouldn't specify work experience because they thought that having that would mean that they wouldn't get their study permit. It seems kind of innocent, but there was an active decision to not include information, which is very trivial. But had the officer had that information, they may not have issued the study permit because they might have said, actually, no, we don't think that this is appropriate for you. So what can seem innocent isn't actually innocent as well.
I think I've also seen situations where people have left stuff out because there's only sort of 3 spots in the form and they got to 3 and then they were like, well, that's the end of that.
Absolutely. That's not the end of that. And again, you can justify it, but that doesn't necessarily mean that you will be protected by these kind of safeguards that are in place. Like everything, there's a spectrum of misrepresentation.
What are your quick takeaways for people from this chat if they're looking to avoid misrepresentation?
Yeah. First of all, anyone should avoid misrepresentation. Own every piece of information and document you submit. So you're responsible for verifying that all information, documentation are genuine. So even if your agent or your consultant has prepared them, if anything turns out to be fake or misleading, it counts against you. You're the one that is responsible. So pay attention to everything, review everything. And part of this means ensuring that you see and approve everything. So don't just let your representative submit. You want to see what they're submitting and you want to sign off on that, on those documentation. That's very important. Material misrepresentation doesn't require intent. So innocent mistakes can still trigger that 5-year ban. And the best thing to do is answer every IRCC concern fully and promptly. So if you do get a procedural fairness letter, address each specific point that they've raised with a clear explanation and supported documentation. Don't ignore it. That is not an appropriate response, and it will lead to a refusal or a delay in your file. And it's usually worth consulting with a qualified immigration professional when you receive procedural fairness letters. It's not just a case of responding with the documentation. Sometimes it can kind of be a bit of a game of chess with IRCC. You want someone that's played before working for you to give you the best possible shot.
I think we can at least hope that sort of an ethical and qualified immigration consultant would have responded to the procedural fairness letter query about the fake marriage certificate. If you reach out to an immigration consultant, you may have a better chance of overcoming the fairly high barrier.
It's always good to have someone work with you to help you plan out your approach.
All right, thank you so much for those. This brings us to the part of this video where I shamelessly plug our newsletter. If you just head over to the Moving to Canada site, you can sign up there, and we regularly share tips. You'll often get insights from us. Usually Rebecca and I are sharing these before you'll find them anywhere else. So yeah, I strongly encourage you to head over there and subscribe. You can unsubscribe anytime if you don't like it, but we really hope that you'll do.
And I'm sure you will.
Yeah, me too. All right, that's it from us today. Thanks so much for jumping into this chat with me, Rebecca.
Thank you for having me.
See you next time.